Hi, I'm Floyd Abrams, and this is Speaking Freely. In the last few months, we've had two libel cases tried and decided, cases that were of enormous public interest, which led to enormous publicity, and which led some people, at least, to have increased interest in just what is libel law really all about? Why do we have it? What's the purpose of it? And how do these cases fit in? And so I thought it might be interesting for you if we put together a few little bits from each of these great, much watched, much debated cases. We put three little sections from what I'll call the Johnny and Amber uh, for you to look at. And then I'm going to talk to you about them. And one longer piece from the more recent Alex Jones case. And I'll talk about that. But before we do either, let me just start with a few words about libel law. The purpose of libel law everywhere is to make sure that people's image, people's impression of other people is not false, and that we find a way to protect the reputation of falsely accused people. Falsely accused by words, falsely accused by pictures, falsely accused on television, online, in writing. We have libel cases, and England and Canada and other countries have libel cases from all different sorts of media, but all are about the same thing. And the same thing again is the restoration of unjustly tarnished reputation. Now, as you may know, we and other free countries do this with libel law that's really quite different from one country to another. I'll have a word to say about that at the end. But as you may know, we provide more protection for even false speech if they're about public people. More protection because we think it's so important that people be free to criticize members of Congress, people in power, the head of unions, famous movie stars even. And so we say basically, even if somebody gets it wrong, innocently, not on purpose, innocently, and something is false that is said, unless there was knowledge of falsity or real serious doubts about truth or falsity, that there can't be recovery there. In England, in Canada, and most other democratic countries, they're a lot stricter, as it were, more judgmental in the sense that if you say something that's untrue and it hurts and it does damage, that's the end of the matter. You shouldn't be allowed to do it. And regardless of whether we're talking about a famous person or not, in those countries, what they focus on, almost all that they focus on, is was it true or was it not true? But we'll see in these brief examples that I thought I'd show you just what the American system is, how it works in the sense of what it is that one side or the other's got to prove, and what sort of things might lead to a finding of no liability, even if something that is said is wrong. So let's start with the Johnny Depp case and have you have a look at three portions of that case.
So any damages that he suffered in his career are not because of this op-ed. And it's time to make Johnny take responsibility, to tell him, Mr. Depp, stop blaming other people for your self-created problems, to take responsibility for your own life. And it's up to you, ladies and gentlemen, to make him do that. It's up to you, because you are uniquely qualified to do that. No one else has the power to do that. Only you, to tell him enough is enough, to stand up for the First Amendment, to stand up for the truth, and Amber's right to speak it. Thank you.
Ms. Heard and her attorneys have talked a lot about this, in this trial about the First Amendment. They've talked about the importance of free speech, and we agree. I'm a lawyer. Of course I agree with that. But the First Amendment doesn't protect lies that hurt and defame people. And there's a difference. Ms. Heard has no right to tell the world that Mr. Depp physically or sexually assaulted her when that isn't true. That's not protected speech. Our U.S. Constitution doesn't protect that speech. And it is a core value of American society that you are innocent until proven guilty. There is a presumption of innocence in this country. A person's life cannot and should not be destroyed by a baseless charge and no opportunity to defend yourself. That's why Mr. Depp had to bring this claim. Ms. Heard was never going to stop calling him an abuser. The only way to clear his name was to stand up in this court, where both sides are bound by the same rules of American law. A jury would be tasked, you, ladies and gentlemen, would be tasked with deciding once and for all Ms. Heard's lies could be exposed in a fair and impartial process.
This is not only about our First Amendment right to speak.
But here's the thing about the First Amendment. The First Amendment protects free speech. It doesn't protect lies that amount to defamation, and that was the issue in the case.
Yes, exactly. You can't go into, the free speech does not protect you if you go into a crowded theater and you scream fire. We get the concept of free speech from the Greeks. My understanding of what that means is not just the freedom to speak. It's a freedom to speak truth to power.
But truth is the word.
Yes.
And that was the issue.
And that's all I spoke. And I spoke it to power, and I paid the price.
I'm sure all of what you've just seen brings back to a lot of you a lot of what you saw at the time. The ratings were very high, as you may recall, and the amount of national public interest was enormous about that case. So what shall we say about what you've just seen? I think what we say is this. When I'll call them by their first names because we all think we know them now. When Amber says, I was speaking truth to power, what I was saying was so. The jury didn't believe her. That's a fact issue. The issue is what she said about Johnny true or not? That was the core issue. It's the first issue. It's the key issue in a libel case. And in America, that's always been true. But there was something more, as you saw, and something more that came up. You've heard the words First Amendment mentioned. It's because of the First Amendment that we go beyond truth, that we don't just limit what we're interested in and what we focus on in our libel cases on truth or falsity. I mean, that's the beginning. If something is said that's true, that's the end of the matter. There can't be a libel verdict because there's no libel. But we go beyond truth or falsity, and that's what you've seen talked about in the last two of these three segments. What were people thinking? What did people believe was the case? It can be a defense under American libel law. if a public person is suing, as was the case here, a public person suing about things said, that even if the things aren't so, if they were believed, that there's no liability. That's why the judge in the Depp case told the jury that after finding out, after determining whether what she was saying was true or not, this was his lawsuit, so what she was saying was true or not, the next thing to focus on was it believed? Did she think it was true when she said it? Did she say it in good faith? And the jury basically came out against her on that. And if they hadn't, they couldn't have ruled in his favor, because certainly Johnny Depp is a public figure, and therefore, as a public figure, had a higher burden of proof than would otherwise be the case. A point about why we talk about burden of proof in the way that I'm talking about. Why do we say that even if you say something that's false and it's about a public figure and the public figure sues, there can't be liability? It's because the Supreme Court has said First Amendment values, free speech values, are so important and so fragile that if all we ask a jury to look about is truth or falsity, criticism of people in power will be inhibited because they'll be afraid if they get it wrong, they'll lose all their money. They'll have to pay an enormous libel judgment. They could be sued too easily. And so again, we take that extra step of saying in a public figure libel case that proof has to be both it wasn't true, and you either knew it wasn't true or you suspected it wasn't true. Now let's turn to the Alex Jones case, which has some very different aspects to it. And let's watch a terrific cross-examination by Megyn Kelly on her broadcast of Alex Jones.
At the top of that list is Jones's outrageous statement that the slaughter of innocent children and teachers at Sandy Hook Elementary School, one of the darkest chapters in American history, was a hoax.
I lost my son. I buried my son. I held my son with a bullet hole through his head.
Neil Heslin's son Jesse, just 6 years old, was murdered, along with 19 of his classmates and 6 adults, on December 14th, 2012, in Newtown, Connecticut.
I dropped him off at 9:04. That's when we dropped him off at school with his book bag. Hours later, I was picking him up in a body bag.
Alex Jones repeatedly claimed that the shooting never happened. Here he is on InfoWars in December 2014.
But it took me about a year with Sandy Hook to come to grips with the fact that the whole thing was fake.
You said the whole thing is a giant hoax. How do you deal with a total hoax? It took me about a year with Sandy Hook to come to grips with the fact that the whole thing was fake. I did deep research and my gosh, it just pretty much didn't happen.
At that point, and I do think there's some cover-up and some manipulation, that is pretty much what I believe. But then I was also going in devil's advocate, but then we know there's mass shootings and these things happen. So, again.
But you're trying to have it always, right?
No, I'm not.
If you wrongly went out there and said it was a hoax, that's wrong.
But what I already answered your question was, listeners and other people are covering this. I didn't create that story.
But Alex, the parents, one after the other, devastated. The dead bodies that the coroner autopsied.
And they blocked all that? They won't release any of it? That's unprecedented?
All of the parents
even the
decided
reports.
to come out and lie about their dead children.
I didn't say that.
What happened to the children?
I will sit there on the air and look at every position and play devil's advocate.
Was that devil's advocate? The whole thing is a giant hoax. The whole thing was fake.
Yes, because I remember even that day, I'll go back from memory, then saying, but then some of it looks like it's real. But then what do you do when they've got the kids going in circles in and out of the building with their hands up? I've watched the footage, and it looks like a drill.
So what about that exchange that we've seen now with Alex Jones? How does that fit in to libel law? I mean, of course, what Jones said was about the worst thing I can imagine anybody in any libel case said about the person or the people that wound up suing. I mean, 20 kids who were 10 years old were murdered as they attended their first grade class. And Alex Jones basically went on the air and on his air and said it was all a fraud. It didn't happen. None of it really happened. These were actors, not parents. There are no dead children. I can hardly imagine a stronger libel case than those people had with respect to Alex Jones. So, what was his defense? Now, I should say that in the case, the reason that he lost was that he wouldn't turn over any documents, and he was obliged to do so. And the court therefore ruled that he couldn't even make a defense. But we knew what his defense was, and I think the jury found out clearly enough what it was that he says he was saying, or the basis of what he was saying, because he was examined even on the issue of how much money he had, and therefore how much a jury could award. So in the Alex Jones case, then, how does our libel law differ from that of other democratic countries? That's the same thing I talked about earlier. What he said was indefensible. He really made no effort when he talked about it to tell a jury with parents present of a dead 10-year-old child that it was all a fraud, that they didn't exist, that the boy didn't exist. I mean, this is madness. And he didn't say that. What did he say? And it wasn't easy. It wasn't easy to sort of conjure up something to say. One of the things he said in his defense was that, and his lawyer said this, that there were so many different theories about what happened, so many different views about what happened, that Jones got, this is my language now, sort of carried away. He couldn't tell truth from falsity. He couldn't manage to have a straight view. The lawyer said it's like looking at a mirror which has a lot of gook on it. So you can't really make out what the face is that you're looking at. Now, like obviously, that's hardly persuasive, and no one was persuaded. And again, the way this came up in the Jones case, again, he hadn't turned over documents he was obliged to turn over. So a default judgment, a judgment entered by the judge saying, I won't let you go on. I'm not going to let you try the case and not turn over the documents that you said you wanted to turn over. But anyway, in the course of the how much money issue in the case, necessarily the question came up, sort of, how could you say these things? What was in your head that led you to say them? And one of the things, again, that I found interesting about that is that is the the core area in which our libel law differs so much from that in other democratic countries. He wouldn't even address that. It wouldn't be relevant. It would be off limits in a libel case in Canada or England, or basically throughout, so far as I know, Western Europe or other democratic countries. I mean, I've taught about libel law for a lot of years in law schools at Yale and Columbia and NYU, Brooklyn Law School. And one of the things I find most interesting is the reaction of our students to the difference in the legal approaches taken in the different democratic countries. A final word on that. There is a hot dispute within the United States Supreme Court right now about whether we should continue to provide that very high level of First Amendment protection that we give, and that arose out of the very famous case, New York Times against Sullivan from 1964. And that was the case in which the court for the first time said, well, we're going to look beyond truth or falsity. We're going to look into the state of mind of the speaker. And if the speaker knew what he or she was saying was false, then at least that element had been met by a plaintiff suing. Or even if they weren't sure, if they really didn't suspect even that what they were saying wasn't true, that they shouldn't be held liable. That's very controversial now on the Supreme Court. And it seems that we have at least 3 members of the court who are prepared to review that again, to take a new look, something that lawyers like me who do First Amendment work and write about the First Amendment find especially dangerous and especially concerning to us. But we do see in both of these cases that there's a lot of similar legal language used because our libel law takes account in a way that simply isn't true elsewhere, the need to protect even some false speech for the good of assuring that people won't be afraid to speak out about people in power, people in authority, people who have great impact for one reason or another on other people. Thank you very much. Good to see you all again.